Eric Theuri, Dr. Eric Omolo, Dr. Martin Olo, and Dr. Duncan Ojong. And we are at the conclusion phase because in the next 7 or so minutes, Parliament should be on to commence the business of the day. And of course, the main business today is a special motion to impeach Deputy President Rigathi Gachagua. Dr. Martin Olo, I had not gotten to you, and we were talking about what Parliament will be doing today. So he thinks that you vote on each of the grounds at the National Assembly. So the 11 grounds, there are 345 members at least in the National Assembly. Some will appear, some will not. There is an option of voting electronically. There is an option of voting in a way that Kenyans can follow what is your vote. If you have to vote 345 11 times, that's a lot of time which may not be available. What do you think is the best outcome here, knowing also that Kenyans are very keen to see how their representatives are voting?
You see, Sam, what we need to understand is that there are only 3 grounds for impeachment. One is the violation of the Constitution, and the other is serious reasons to believe that the Deputy President has committed crimes, and the other is gross misconduct. So those are the issues. So the rest are charges that are answering to those issues. So one would say that, do you believe that the Deputy President has grossly has been found guilty of gross misconduct? So that would be, then of course everything else is an attempt to substantiate that. Okay. So I would see those are the 3 grounds upon which either there's a threshold on each ground, and therefore we vote on it that way, but not on issue by issue. For example, the issue about property and whether this property were found or bought with illicit money, that's one argument. And you can come and say, yes, this, that, and then you say, yes, there's corruption. And if that amounts to gross misconduct, you can come. If it amounts to a crime, you can come to that issue. Has Gachagua grossly violated the Constitution? I don't see any ground that points that whatsoever. Whatever is being alleged is conjecture. And like my friends here, what is happening is a political process. The legal process will begin after the decision that the Parliament makes. That's when now we'll deal with the legal issues, because what is the threshold to say that somebody has grossly misconducted himself? What is it that you want to say that because somebody said that this government of shares that he violated which constitution, and what's the threshold? So I don't see any of those holding water legally after. For now, they can vote. As I've said, it's going to be a lynching process. It's not a legal process. Where you have MPs who say they don't know how they even found themselves supporting it. Where you have people who are being threatened if they don't appear and if they don't vote one way or the other. That is not a legal process. So we will wait.
Sad.
What is it?
It's very sad what you have said.
Yeah, but you see...
Because, I mean, he has only interacted with this thing through TV. But
so I don't read. I haven't read the motion.
Or read the motion. Yes. But apparently people who are placed in that thing, including Gachagua's own member of parliament, that have gone through public participation as an individual, that is now going to have a whole day looking at those things.
You're
to him,
talking about
the MPs.
Eric Omombi.
Yes. To him, he has
done them. Information he didn't go for the public participation in Madeira.
To him,
I like the fact-checking that you're making on this.
He has the report.
Like Trump is not very happy with fact-checking.
He signed the motion.
He signed the motion, and he has the report. Public participation does not mean you have to be there and listen. You can see the report. You know, there is no requirement for public participation that the MP must chair it. Actually, that is not the requirement. The requirement is that you get the report and look at it. But if you look at all this, if citizens and Kenyans, if the MPs put their foot down, they will have dented the issue of corruption, the issue of ethnicity, the issue of balkanization, once and for all.
You know, corruption has never been a political issue in this country.
Dr. Joang, I take interest that you talk about Rigath's own MP who went through public participation. There's a report that has been shared by Parliament just right now that Madeira constituency, in the public participation, 5,598 people showed up or filed their responses, and out of that 97.59% voted or ticked I do not support. 2.16% said I support. What should this do to the Member of Parliament of Madeira?
Nothing. It is that simple.
There's no mathematical formula to how much weighting you give public participation. As it is given, it is very important view. But the MP stands at a position of trust where they are told at this time as the Member of Parliament, listen to us. Yep. If you are to disagree with us, have very good reasons. And he will have very good reasons.
Do we have public participation law in place?
There is no public. No.
So whatever is happening is a charade.
I want us to lose, I mean, not to lose, but to close, to tie the loose ends as we conclude.
You have said very bad things.
If you don't have a law, what is it that you're going to... What standard are you going to...
Constitution.
Sorry, Dr. Komolo. So eventually, if this matter gets to the courts, there's a spillage happening somewhere. If this matter gets to the courts and they are called to interrogate, can they go to the merits of the allegations, or are they just to look at the procedure followed?
We are still a bit far from there, but the general trend has been that courts have intervened when it comes to the issue of the process, particularly on this conversation around public participation, and obviously to try to bring sanity in the process of impeachment, because particularly for counties, it's often hurried, often the MCS often proceed even after there's a court order in place. I think that's the case in Kericho at the moment. Yeah. So it may be speculative, but I did hear the Deputy President say that the public posting, so you can easily speculate that that's a ground that will eventually end up in court. Yeah. Having said that, I don't think that this process should even get to the stage where we now go to the High Court to intervene. We do not need to overstretch the mandate of our courts in political processes, particularly something as significant as the impeachment process of a president or a deputy president, because we should ideally be getting it right from the outset. And that is the question that I think Dr. Joang and Dr. Lau have been debating here. What is the role of an MP? Yeah. Apart from appending their signature, which is a formal process to bring the motions to Parliament, what then do you do to ensure that the people you represent have their voices heard? Because MPs are not there to speak for themselves. They're there to speak for the people who elected them. Right. In a particular case of Madeira MP that you've shared the data, I'm not sure that 5,000 is representative of the real population of Madeira, but this could be the people who are either mobilized or who are, you might say, in terms of civic education, are more conscious to then participate in the process even at short notice. And if it is true that 95% of them have said no, then I don't think the Madeira MP has latitude to then go against their wish, because then who is he representing?
You know, it's interesting you said that if it is true, are you doubting the report of Parliament?
I've not seen it. Remember, Sam, I don't represent Parliament, I don't represent Gachagua, I don't represent Mwenge Mutuse, the MP and all that. I look at it in terms of the objective standpoint of the Constitution and what we expect impeachment process to amount to. Having said that, and I did say this earlier, I still expect Parliament to restore its glory as an institution that represents people, that is not only seen to be independent, but is actually independent. And that means all MPs have then to interrogate their conscience in terms of where we are, what do we want for the country at the moment, and whether impeachment or lack of it is the right thing to do at the moment, particularly when there are several people in the country saying, look, our priorities are A, B, C, D. I still expect them to give the Deputy President, I'm not sure 2 hours is fair. I expect them to give him a lot of time because this is also a career-changing process. Impeachment, remember, when successful to the end, then you cannot hold public office for, I think, forever, I think. In other countries, normally about 10 years or so. So when you're doing things that are career-altering, then you expect that the process be fair, reasonable, objective, and hopefully not influenced by graft. Because there are already conversations that man is exchanging hands here and there. But look, I'm going to spend the rest of the day watching this. Remember, all of us here are going to vote in 2027 one way or the other.
Yes.
And we will be voting based on what we see our representatives to be objectively acting on and not going because I am made to understand parties have not openly whipped their members. If that is the case, that means party leaders understand that this is one of those spaces where MPs should be acting independently and objectively, of course, and senators later. And if we elect you and you don't do that, then of course you will meet the consequences in 2027. Until then, let's wait for the prosecution of the grounds, and then the response of the Deputy President and the objectivity of the voting process.
Interesting. And for you, Wakili, as we conclude, he quite avoided what I asked about the specificity of the focus of the courts. Will it be on the process or will it be on the merits in a situation where Parliament, both the National Assembly and the Senate, confirms some of the allegations and says they are impeachable? Can the High Court or the courts, can they alter that, or they'll just look at the process?
I don't think that the courts will conduct a merit-based review of the allegations with a view. You know, ordinarily what we would say is that perhaps the courts reviewing it and determining that they would have arrived at a different conclusion than Parliament. The courts would not undertake that kind of exercise. But for example, if the Deputy President is removed on the basis of allegations of violation of the law, then that is an area which the court may want to look at in terms of, if you are saying that someone has violated the law, what are the processes? Because it is a bit intricate to just make an allegation you have violated the law, if then the certain processes may not exist to actually demonstrate to a desired threshold. So it might come to a question of threshold. If you are saying, for example, someone has violated the law, what do we look out for in terms of that mandate? And you would understand that when it comes to questions perhaps of the violation of the law, Parliament may not have primacy of determination of those issues because that could be a mandate that is reposed elsewhere. And as we understand the process of impeachment, that sometimes because someone holding office has committed a crime and there is evidence of commission of that crime, but that person is using the office to prevent accountability for that crime, then an impeachment process is introduced for purposes of seeking accountability for the violation of the law. So I think those are the issues that we are going to see play out. The other critical thing that we are going to see play out is that this is the first time that as a country we are conducting impeachment of in the deputy presidency or under the Article 145 procedure to 150.
Right. So
there is a bit of innovation that is being done by Parliament. For example, the innovation that they did with regards to public participation. Would that be adequate? And of course, the other question would be, you look at it and you almost get a sense that Parliament in a way intended to carry out a referendum on whether the deputy president is actually popular or not popular. So, again, that is something that the court may look at in terms of this person got elected into office, you conducted public participation. Fortunately, the court did intervene and say, you know, roll it out to
the constituency level.
To the constituency level. Again, that might become a problem. The other question might become, and this is also a question that the Deputy President has been asking, before I give my response, can you take this to public participation? Because then the other side is not available to the public, and so they give a biased feedback on the basis of the allegation. And now, what has come out is that some of those allegations, for example, where what the Deputy President was saying, that he was sold a piece of land by an existing member of Parliament way back before he got into office, and that member has signed. If that information was out there before it went for public participation, would it perhaps have changed the views of those who gave a yes or no opinion? So those, I think, would be questions that the court may interact with. And unfortunately, and we all know this, that there was a law that was intended to guide the impeachment process, which has not been enacted. And that law would have probably filled in these gaps and would have looked at all those issues. So in the absence of that law, then the court then would have to look at what the constitutional principles, because the Constitution then has to be interpreted holistically. We'll be looking at what does public participation mean. In this instance, should they have just looked at one side or two sides? Those will be things that the court will be looking at. And those, ideally, are also procedural issues that ultimately have a bearing on the merit of the decision that eventually was reached. So that's what I foresee playing out.
Okay. Interesting. We're still expecting for the session in Parliament to commence. The members of Parliament are walking in for the start of the sessions. Now, I have a few minutes remaining before you take a break and come back to the House. I don't know if you have something to say as you close.
Public participation does not turn to be a trial by jury. And that's why even courts don't come and say, hey, you guys, you have been listening to this case. What do you think? Is this guy guilty or not? There is those who that responsibility is put on their shoulder because it is moving or metamorphing to people demanding that it's a trial by jury, sort of. No, the responsibility is placed in the hands of the Member of Parliament. And I like what Theory is saying. The Constitution did not envision them to be lawyers, to be judges, but in their many and in their various skills, they are entrusted to be the people who will do this. Instead, the Constitution gave them a higher threshold to impeach, which is 2/3. The court comes in, and you know the court have always been invited to some of this, which we call politicization of court. They have been invited 20 times. They have rejected those invitations. That court generally can only look at process, but they are not going anywhere. Even if you look at the Wambora jurisprudence, and we are building jurisprudence on impeachment because this is the first time now that the Deputy President is being impeached, the court cannot turn to be the Parliament. That role, the same Constitution that gave court their powers, gave it to the parliamentarians. Now, if they do things and people don't want, the politics have a way of balancing that. I think that this impulse to beat up the Parliament, to talk of Parliament as if they are not an institution of the Constitution, and try to run as if the courts are the temples of justice, and they don't operate in a vacuum, not recognizing that there is the Parliament of the people, is going to run amok. If I was part of the legal team, I will have really made the Deputy President talk so well about Parliament. You don't throw, they talk of throw mud at a dog so that you can justify the allegation of they are corrupt, they are not, they have not looked much at this issue, they have ill motive or ill will. We'll just give them more appetite to impeach you more. This is a dignified house.
Is it a possibility that they're being whipped from outside the house?
It doesn't matter. You know what is bad is undue influence. Influence is there. Even when I came here, there is influence to where to park. What the law does not allow is undue influence. So they are parliamentarians, they are politicians. There will be at any time they operate. There is various faces. There is the public pushing. There is the party. There is the personal, but are they undue?
There's a direct answer. Yes, they are being whipped.
Yeah.
No, they are being whipped. The issue is not undue. They're being whipped. When Republicans are called to vote, they vote the way of the party. So parliamentarians are being whipped. And that is also part of the parliamentary procedures. I want to say this, Sam, because it's our closing. There is a way in which Dr. Ojwang speaks and wants to give the impression that because the impeachment process is a parliamentary process, it can violate the Constitution, it can violate the Bill of Rights, and that it can obviate such a person who is aggrieved to seek redress further. Nothing could be further from the truth. As a matter of fact, public participation was not meant to be a jury system. However, it was meant to reaffirm Article 1 of the Constitution in sovereignty of the people and to affirm the provisions of Article 10 of the Constitution, making it a requirement in terms of public participation and also good governance and accountability, transparency, and openness. So that when you take to a people a motion which you have not given them time to process, they have not understood even the basis upon which you have made those allegations, you are expecting them to act in ignorance and therefore without any relevant information that can make them make good decisions. So public participation is an ingredient well embedded in the Constitution to enable people to continuously hold those they delegate power to. Parliamentarians are delegatees of the people. To that, the executive is a delegatee of the people. The judiciary is a delegatee of the people. So public participation is not a charade. It's not something you just do over 4 hours without proper information and you come back and you say, we did it. It is a serious, sacrosanct exercise that should not violate the people's sovereignty.
A very important provision because it is one of the national values and principles of governance. Yes.
Sam, you know, this being a politicized process, you expect some of my ordinarily very objective friends to take sides. So I'm not very surprised that Dr. Ojwang and Dr. Olo are taking sides on particular issues here and there, even when